People versus Robert Durst. Mr. Durst is present. Appearances, please.
Good morning, Your Honor. David Presnoff and Richard DeMarin, Judge Lewis, on behalf of Mr. Durst. Mr. Ray is absent today. I'm appearing with your permission for him, Your Honor.
To the people.
John Lewin for the people, Your Honor. We also have Habib Balian, Eugene Miata, Ethan Milius, and Tim Henderson.
Thank you. We have our court reporter today doing a live transcript for Mr. Durst to accommodate his hearing loss. Mr. Durst, you were willfully absent yesterday. I understand that there was a disagreement about your wheelchair. I want you to know that that 1043 of the evidence of the California Penal Code provides in the absence of the defendant in a felony case after the trial has commenced in his presence shall not prevent continuing the trial to and including the return of a verdict in case when the defendant is voluntarily absent. Yesterday we did not do matters of substance, but not critical issues, but issues that we ordinarily would do at sidebar. But I'm admonishing you now that I will proceed with witnesses and evidence even if you refuse to come to court. If you're approved for court medically, as you were yesterday, you must come to court. All right, that's all. Just an admonition. All right, now we have an issue of a juror. We just had a communication. We interviewed a juror who, juror number, what's the number? 3090, who alternate 7, who had actually, we talked with her yesterday, but she had a recollection that today that she had indeed looked briefly at an article, had looked at an article involving a mistrial, had enough of the substance of the motion for a mistrial to know the grounds that jurors supposedly would not remember evidence, and she took umbrage at that. She then texted another juror. We did interview that juror. That juror responded appropriately. That juror phoned her and said, "Don't text me this information." But this, the content of this was contrary to the orders of this court. Is there is there a motion on behalf of regarding this juror?
The only thing I wanted to add, Your Honor, is that she didn't just come across the article. She affirmatively Googled and looked for it.
All right.
In direct contradiction to the court's order.
Yes. Anything else? So you're moving to remove? You asked that the court remove this juror for cause?
Yes, Your Honor.
Mr. DeGarren?
We oppose.
All right. The good cause has been shown. She violated the court order in a couple of ways. She went ahead and looked at an article, and the content of the article she felt actually biased towards the defense. I'm not sure why the defense doesn't agree to remove her, but it seems perhaps you have the best of both worlds in objecting and knowing I'm going to remove her, because clearly she did violate her duty not to read material about the case, and when she did, she shared it with another juror. So I'm going to remove her for
Your Honor, for the record,
cause.
for
Yeah.
potential appellate purposes, we would ask, Mr. DeGarren is saying that he is not agreeing that there's cause. So we would ask him to just briefly state on the record why he believes there is not cause, because you could have an appellate court that is analyzing this, and I believe there is cause. So in other words, to go with what the court said is, they are having it both ways on this. I think this is a deliberate attempt to try to set up an appellate issue, and if it isn't, then if Mr. DeGarren is saying there is not cause, then he should address the court so the court can look at his argument and determine that maybe there isn't cause.
All right. Is there a reason?
We oppose, Your Honor.
All right, thank you. I think that speaks volumes. All right, we'll, the juror will be excused. Will please bring in that juror, our bailiff or our judicial assistant. He can't. He can't. Maybe, okay, RJA will do that. It seems to be quite long. I am going to limit you to 2 hours. I'll give you a warning sign, but you might need on the fly to collapse it.
I'm going to tell you something that's going to shock you, Your Honor.
Yes?
And if anybody wants it, I'm available. I will be well short of 2 hours, and I am offering 5 to 1 on $1 for anybody who
Thank
wants
you.
to take that. I understand my reputation precedes me that I would go over it.
Thank you.
We've actually timed it, Your Honor. I'll be on.
Thank you.
Mr. DeGuerin, for the record.
Please face the flag of our nation and recognize the principles for which it stands. Department 1 is now in session. Honorable Mark E. Wyndham, Judge, presiding.
Please be seated, everyone. Good morning. Welcome back. I'm going to look down here to see you because I'm not on the screen, but hello. My apologies for the delay. There's sometimes a little bit of adjustment and decisions we're making about unanticipated developments with the physical space, et cetera, and that's what we're taking our time doing. Those things are mostly resolved, so I don't think we'll have such long delays. How are you? Can you hear me okay? I'm going to try to project from. They told me this little microphone I had a little microphone here, and it was for traffic cases. It went to a little cassette recorder. It wasn't even working. I'm, trying to get it to go, and it would to no avail. Anyway, welcome. We have, in the case of People versus Robert Durst, Mr. Durst is present, and he's represented by Mr. DeGuerin and his team. Mr. DeGuerin, will you introduce the other members of your team?
Yes, Your Honor. This is David Chesnoff.
Good morning, everybody.
Don Ray is ill this morning and is not here, but he will be here tomorrow. Chip Lewis. And also with our group right now, Lauren Childress, who you probably remember, she had her twins. She's going to be assisting me. Tommy Mingledorf is a lawyer from Houston that's assisting us also, not counsel of record.
All right. Thank you, Mr. DeGuerin. And Mr. Lewin, will you introduce yourself and the prosecution team?
Good morning, everybody. So, nothing's changed. It's still John Lewin, Steve Balian, Ethan Milius, Eugene Miata, and the youngster of the group, Tim Anderson.
All right, ladies and gentlemen, we are going to, let's see, do we move up our jurors yet? So we need, space 6 would be alternate 1.
5.
Space.
5.
We need to fill 5 and 6, Your Honor.
Yes, I guess it doesn't matter. I think 6 was excused before 5. No? Am I backwards?
Say what?
Yeah, 6 was excused first.
So it should be alternate 1 should take seat 6. Who is alternate 1? What is that juror number? Should be in seat 13. Yeah, seat 13. We're gonna upgrade you a little bit to seat number 5. Not much difference. 6. Seat number 6. I'm not sure that's better, but that's where she is. I'm going to move you there. If your seats are problematic for you, we can talk about it. But yes, please move over to number 6. That helps us keep track of you. And then juror number, alternate number 2 in seat 14 would take seat number 5. And who is that?
0508.
0508, would you kindly take seat number 5? Shall we move jurors into those seats? I think these seats are a little bit better, so we're going to start to move you in that way if need be. So in seat 13, is juror number, is 15. Oh yeah, we're gonna scoot you up. Please come forward a couple seats. We're gonna put you in 13, lucky 13. And our next juror goes into seat number 14. So 16, juror 16 is, oh, there you are. Even much better seat. 16 goes into 14. I shouldn't say that because I'm going to move somebody else into your seat. Okay. 17 can move up to 16. Oh, 17 moves to 15. Oh yeah, that's good. I'm not thinking clearly, but just in sequence. Move up in sequence. Who's next, brother? Alternate 6 goes into seat 15. Seat 16. Okay. Can move forward a little bit. You guys are self-organizing. I like that. You got the pattern. One reason I like this is if there's some observers who come in, because we are going to have 1 or 2 people from the public who are able to get a seat, perhaps 1 or 2 journalists. I think we got you in. Oh, do we have the media at 19? I'll let Robin sort that out. Oh yeah, you don't have to take the broken chair. Move over 1. That's still good. Couple of points. I was asked our sergeant here, in charge of the sheriff's department in this building, suggested to me that if you were to take the first floor from the parking lot, you can avoid cameras and media. That's probably better to take the first floor from where your structure is, like enter on that side and then come through on the first floor. You have a question?
Well, I have a concern with the media, because it seemed outside that they're being sneaky about taking our pictures and recording what our numbers are.
So,
And
okay.
I'm very upset about that.
Yes, okay, so you are what seat are you in now? You're in, and what's your last 4 numbers? Last 4?
6'8".
So I was informed by another judge that there was a person who was taking people's pictures, and he's not media. He was not a media person. He's this morning.
Yes.
Yeah.
And I've read where they named, didn't give our names, but they said that I had been in Japan and was a teacher and I smiled too much.
And they can't. Well, you can't smile too much. Second of all, there's no way to know. Oh, they can see your smiling eyes, but no, that's not acceptable. So you need to tell the court. This person who was taking pictures went into custody today. So we take it very seriously.
Yeah,
Yes, so I don't think that was a legitimate media person. We do, so I only have 1 media seat right now, and because we usually had a few journalists, I have permitted 1 camera, so that it's shared by all the media, and that person's going to film over your heads. Cannot film you; he's behind you, so that he's filming the witness. Yes. And I have a little bit more information to share with you. All right, I got a little bit more of the description of what had been happening with members of the media, who, not just the person I'm describing, which is sort of an odd case, frankly, but with people who are trying to photograph you or take your number down and try to figure out who you are, that kind of thing. So our media office is going to be vigilant about policing that and bringing that to my attention. I actually put a lot of work into the media order. There are very strict rules that prohibit that. That order has been posted. Violating my order is a violation of law, punishable by jail or fines. So I regret that this has happened. We'll find out who is doing it, and we will do something about it. Because you have a right to privacy, to do and not to have anyone interfere with you or make you think they're interfering with you. You are independent judges of the facts here, and no one outside of this courtroom can invade your privacy or influence you. Now, when we interviewed you, we sealed those questionnaires, right? We sealed the transcripts of our inquiry. All of that information is protected, and that's protected for your privacy. I don't want you to worry about your privacy, and I will take additional steps to protect it. I mean, obviously that went too far with you, way too far. So I'm going to find out who's responsible for that. But
That's before we broke, but last March, where I read that about some jurors, and I was like, oh my God, why would they say that?
I see.
Kind of giving away who I am.
I see. Okay. Well, we'll follow up on that one. So, all right, ladies and gentlemen. It's time for opening statements. And is that your computer there?
Yes, Your Honor.
You flip down the top. I think I'm going to come down again.
Put this on the ground, Your Honor. I can't close the top.
Yeah.
Thanks.
Okay. Did you break it?
No, I
Okay.
can't close.
Just the logistics of this courtroom are odd, right? I mean, to have a jury in the audience, and your view's constricted. And we'll see what we can do. Right now, we're maintaining the 6-foot distance, and we're keeping a cap on the number of persons. But within those constraints, I can make some adjustments. So keep in touch. Let me know if there are problems with your seat. But right now, I thought it was so important that I talk with you again about the instructions. Now, these are instructions that I read to you before, so you'll be familiar with them. But it's been 14 months, so there's no reason. It's really, I think, important for me to reiterate these, because these are the fundamental instructions to you about your work, what we're doing here. So I'm going to describe how the trial will be conducted. I'll remind you how the trial will be conducted and explain what you and the lawyers and I will be doing. Whenever I refer to the people, I mean the attorneys from the district attorney's office trying this case on behalf of the people of the state of California. When I refer to defense counsel, I mean Mr. DeGuerin and his colleagues who are representing Mr. Durst, the defendant in this case. First step in the trial was jury selection. We heard opening statements and these instructions. Then we had a 14-month break. Now here we are again. The trial will now proceed as follows. I'm going to let the people and the defense present another opening statement. The reason why I'm letting them do that is so they can remind you of the evidence you've already heard and tell you again the evidence they expect to present to you during this trial. The defense isn't required to present an opening statement, but I understand they will in this case. The purpose of an opening statement is to give you an overview of what the attorneys expect the evidence will show. Next, the people will offer their evidence. You've already heard some of the evidence. You'll hear more evidence. Evidence includes witness testimony and exhibits. After the people present their evidence, the defense may also present evidence, but the defense is not required to. Because he's presumed innocent, the defendant does not have to prove he is not guilty. After you've heard all of the evidence, and before the attorneys give their final arguments, I'll instruct you on the law that applies to the case. After you've heard the arguments and the instructions, you'll go to the jury room to deliberate. Our system of justice requires that trials be conducted in open court with the parties presenting evidence and the judge deciding the law that applies to the case. It is unfair to the other parties if you receive additional information from any other source because that information may be unreliable or irrelevant, and the parties will not have had the opportunity to examine and respond to it. Your verdict must be based only on the evidence presented during this trial in this court and the law as I provide it to you. During the trial, do not talk about the case or about any of the people or any subject involved in the case with anyone, not even your family, friends, spiritual advisors, or therapists. Do not share information in the case about the case in writing, by email or telephone, on the internet, or by any other means of communication. You must not talk about these things with the other jurors either until you begin deliberating. As jurors, you may discuss the case together only after all the evidence has been presented. The attorneys have completed their arguments, and I've instructed you on the law. After I tell you to begin your deliberations, you may discuss the case only in the jury deliberation room and only when all jurors are present. You must not allow anything that happens outside of this courtroom to affect your decision. During the trial, do not read, listen to, or watch any news report or commentary about the case from any source. And there has been, I'm saving it for you. I'll present it to you. You can read up on everything, but you've got the best view. You're seeing it live. Do not use the internet or a dictionary in any way in connection with this case, either on your own or as a group. Do not investigate the facts or the law or do any research regarding this case. Do not conduct any tests or experiments or visit the scene of any event involved in this case. If you happen to pass by the scene, do not stop or investigate. If you have a cell phone or other electronic device, keep it turned off while you're in the courtroom and during jury deliberations. You can put it on vibrate, but you can't be communicating, obviously. If someone needs to contact you in an emergency, the court can receive messages that it will deliver to you without delay. Any emergency, they call Robin instantly. We let jurors know if there's a problem. During the trial, do not speak to a defendant, witness, lawyer, or anyone associated with them. Don't listen to anyone who tries to talk to you about the case or about any of the people or subjects involved in it. If someone asks you about the case, tell him or her you cannot discuss it. If that person keeps talking to you about the case, you must end the conversation. If you receive any information about this case from any source outside of the trial, even unintentionally, do not share that information with any other juror. If you do receive such information, or if anyone tries to influence you or any juror, you must immediately tell our court, tell our bailiff. Keep an open mind throughout the trial. Don't make up your mind about the verdict or any issue until you've discussed the case with the other jurors during deliberations. And do not take anything I say or do during the trial as an indication of what I think about the facts, the witnesses, or what your verdict should be. Do not let bias, sympathy, prejudice, or public opinion influence your decision. You must reach your verdict without any consideration of punishment. I want to emphasize you can't use any form of electronic research or communication or research, share, communicate, or allow anyone else to communicate with you regarding any subject of the trial. When the trial's ended and you've been released as jurors, you may discuss the case with anyone, but under California law, you must wait at least 90 days before negotiating or agreeing to accept any payment for information about the case. You've been given notebooks. You've been taking notes during trial. Don't remove them from the courtroom. You will take your notes into the jury room during deliberations. I don't want to discourage you from taking notes. Here are some points to consider if you take notes. Note-taking may tend to distract you. It may affect your ability to listen carefully to all the testimony and to watch the witnesses as they testify. And the notes are for your own individual use to help you remember what happened during the trial. Please keep in mind your notes may be inaccurate or incomplete. At the end of the trial, your notes will be collected and destroyed. I'll now explain the presumption of innocence and the people's burden of proof. The defendant has pleaded not guilty to the charge. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because he's been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt, because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to an acquittal, and you must find him not guilty. Evidence. You must decide what the facts are in this case. You must use only the evidence that's presented in the courtroom. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The fact the defendant was arrested, charged with a crime, or brought to trial is not evidence of guilt. Nothing the attorneys say is evidence. In their opening statements and closing arguments, the attorneys will discuss the case, but their remarks are not evidence. Their questions are not evidence. Only the witnesses' answers are evidence. The attorney's questions are significant only if they help you understand the witnesses' answers. Do not assume that something is true just because one of the attorneys asks a question that assumes that it's true. During the trial, the attorneys may object to questions asked of a witness. I will rule on the objection according to the law. If I sustain an objection, the witness will not be permitted to answer, and you must ignore the question. If a witness does not answer, do not guess what the answer might have been or why I ruled as I did. If I order testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose. You must disregard anything you see or hear when the court is not in session, even if it's done or said by one of the parties or witnesses. The court reporter, Rona, is making a record of everything that is said during the trial. If you decide it's necessary, you may ask that the court reporter's record be read to you. You must accept the court reporter's record as accurate. And I'll mention that the lawyers in their opening statements are going to describe evidence that you heard 14 months ago, a small portion of the evidence in this case, but it's evidence that's admitted in this case. If you have difficulty remembering any part of that evidence, we do have a record that will be read back to you, so you can know exactly what was said. Your notes have been preserved for you. You have those notes. But also, that's an example of when you may, if you wish, request that the court reporter's record be read back to you. And you must accept the court reporter's record as accurate. Witnesses. You alone must judge the credibility or believability of the witnesses in deciding whether testimony is true and accurate. Use your common sense and experience. You must judge the testimony of each witness by the same standards, setting aside any bias or prejudice you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors you may consider are how well could the witness see or hear or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that's consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all the other evidence in the case? Do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event, yet see or hear it differently. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or if you think the witness lied about some things but told the truth about other things, you may simply accept the part you think is true and ignore the rest. You'll, of course, be permitted to separate during the recesses, and at the end of the day, I'll tell you when to return. And please remember, we can't begin the trial until you're all in place, so it's important to be on time. Remember, do not talk about the case or any of the people or any subject involved in it with anyone, including the other jurors. Do not do research or share information or talk to each other or anyone else about the facts of the case or anything else connected with the trial, and don't use any form of electronic or wireless communication to do those things either. Don't make up your mind or express any opinion about the case or any issue connected with the trial until after you've discussed the case with the other jurors during deliberations. It's now time for the attorneys to give their opening statements. Remember, what they say is not evidence in this case. It's merely an outline of what they expect the evidence to show. Mr. Lewin will make his opening statement first, and that's because the people have the burden of proof. Then Mr. DeGuerin, Mr. Chesnoff may make their opening statements if they so choose. Mr. Lewin, are you ready?
Yeah, I think we need to just make sure that
Okay.
we're on.
Something just fell.
plugged in. I'm about to review.
Right there.
I didn't make it.
Apologize, Your Honor. Plugging in was unforeseeable.
Let's make sure we're. Ethan, are we up? Good morning. So for some reason, standing here, it feels like I have done this before. I can't quite place it, but it feels like this has happened previously. Obviously, and I'm going to speak up as loudly as I can. If anyone can hear me, please raise your hand. I'll be kind of scanning. This is, without question, this is a new experience for everybody. I have never given an opening statement in the same case twice. And I've never, obviously, gone so long in between. It's a little bit like Groundhog Day, except for it's taken a lot longer. And as I sit here, can you imagine if we went back to, say, the first day you all showed up in January of 2020, and if we put you in a time machine and put you forward, and you came today and you were watching yourselves seated like this, wearing masks, you would wonder what planet, what had happened, etc. It's really been a just whirlwind 14 months or 15 months, whatever it's been. So I hope that all of your families have been safe, and I hope that everybody is going to be able to pay as close attention as they can. As His Honor said, and obviously, and I think both sides are really appreciative. It's taken a lot of work, which Judge Wyndham has had to do, to make everybody safe, to get this courtroom, a real Herculean effort, and the staff. So all of us are extremely appreciative. And we're appreciative that all of you have come back despite whatever personal issues or family issues or work issues that you've all had to overcome, and I'm sure it has not been easy for anybody. My opening statement's about to start. It's just a little bit longer than the first one I gave, so hopefully, all right, I want to see people remember. No, it's not as long. I'm going to be, but that's hurtful. You don't think you want as long an opening this time. I'm limited to less than 2 hours, and I'm gonna be under that. So this opening statement is divided up two ways. So the first thing is we're going to go back and we're going to talk about what we expect the evidence to show. So in essence, what that is that means that it's going to be an opening, kind of a miniaturized version of what we talked about before, with the exception that obviously since that time, there's been some evidence presented, the defendant has given their opening, so we're not in a vacuum where I go back and we pretend that nothing has happened. So that's going to be the first part. It's going to be a review. It is not going to be nearly as comprehensive as the original opening. The second part of the opening is going to deal with the evidence that you have already heard. There were 10 witnesses that testified over 2 days, and we're going to go through and talk about the highlights of what those witnesses testified to. Thankfully, we had audio for all of the witnesses, so you're going to be hearing audio actually of what those witnesses said. So I'm going to start with what we expect that the evidence at trial is going to show. Obviously, you all know who Robert Durst is, and we believe that the evidence in this case is going to show that he is responsible for the disappearance and the death of his missing wife, Kathleen McCormack Durst. We're going to show that Robert Durst murdered his close friend and confidant, Susan Berman. And we're going to show that he did that with the motive and because she was a witness, and by witness meaning that she assisted him in covering up the killing of his wife almost 20 years earlier. Finally, we're going to show that Robert Durst killed, dismembered, and dumped Morris Black's corpse, his body parts, in trash bags into Galveston Bay in September of 2001. So there's going to be 3 killings that we are going to prove. We're going to prove, even though Mr. Durst is only charged, he's charged with the murder of Susan Berman. He is charged with the special circumstance that that was a witness killing. And in order to prove the witness killing, we need to prove to you what she was a witness to, which means we're going to be putting on evidence that Mr. Durst killed Kathy Durst. We're not going to necessarily or have to prove that that killing was murder. You might decide it was murder. You might decide it was manslaughter. It won't matter for the purposes of this case. What will be important is that Mr. Durst intentionally killed Kathy Durst, and then he covered it up, and then he used Susan Berman to do it. That is what we're going to show. In essence, all 3 of these cases, ladies and gentlemen, are interrelated, meaning that everything starts with Kathy Durst's disappearance and death at the hands of Mr. Durst and Mr. Durst alone, and that after that, he had to kill Susan Berman because he feared that she was going to talk, and then he had to kill Morris Black because Morris Black knew who he was and was putting pressure on him. So that is, in essence, what we're going to show. That's going to be the evidence in this case. So let's start with the charged murder. Susan Berman. Now, we've heard, and you started to hear, and I'll cover it a little bit later, you've heard evidence about who Susan Berman was briefly. You heard it in opening last time. What's going to be important, and we're going to go back to, and we're going to have you examining, and we're going to be discussing, what was the motive for Susan Berman's murder? In other words, what happened? And what we're going to be able to show is that the motive for Susan Berman murder, her murder, was not robbery or burglary. How are we going to show that? By the way, can everybody hear me? Is there anybody who cannot hear me? Seeing no hands, I just want to check with Corporal Rona. Are you able to hear me okay? Great, okay. So, how do we know, ladies and gentlemen, that the motive for this murder was not robbery or burglary? Well, we know because there was no forced entry into the home. The windows were locked and unbroken. The back door was found wide open. There was no ransacking. There was no struggle. Nothing, in fact, was taken that day other than Susan's life. Her purse with credit cards, with ID and cash, was on the kitchen counter. The evidence is going to demonstrate that burglars, robbers, they take items. They don't just walk in and execute somebody and leave. Very importantly, and without question, the evidence is going to prove that Susan Berman knew her murderer. How do we know that? Well, because you're going to hear evidence, and you've already heard a little bit of evidence, I believe, that Susan was extremely security conscious. She always locked everything, to the point that she was paranoid. Susan had a lot of phobias, had a lot of just personality quirks, and one of them was personal security. So the idea that Susan would have opened her door to a stranger and let them in the house, by the time this case is over, we're going to put on evidence where you're going to come to the conclusion that that is absolutely not what happened. So, what else do we know? We know that she always locked everything. And we know that because there was no forced entry, that means that the killer had to have been admitted into the house. We further know that upon entering, and this is extremely important, Susan turned her back to her killer. Now, the one thing, if there is such a at least less worse side of being brutally executed by your best friend, is that the evidence clearly will demonstrate that Susan Berman never saw what happened. She never knew it was going to happen. She let Mr. Durst in. She turned around because she trusted him, because he was her close friend, because he was not somebody to fear. She turned around, she took a few steps, and he basically blew her brains out. That's what he did. Now, we also know that the killer, whoever they were, and I'm taking that, I'm just moving that aside for a moment. I'm saying even before we look at the evidence against Robert Durst, we know that whoever that killer was wanted Susan's body to be found. How do we know? Because the killer left a note, what's been commonly referred to as the cadaver note. And that was mailed to the Beverly Hills Police Department. And it was found prior to Susan's body being located. So meaning, because her body is in the house, that the only person who could have sent that note had to have been her killer. We also know that Beverly was spelled wrong. That there was inside the envelope on the outside, it was spelled L-E-Y. Inside, 1527 Benedict Canyon, and the word cadaver. Now, what has Mr. Durst's position been over the years when he has been interviewed, when he has testified under oath? What has he said about the idea that he had found the body, which is now his defense? The defense got up here in opening and said, Mr. Durst, he found the body. But what has his position been over time? Well, this is what he said in 2010. This is the interview with Andrew Jarecki and Mark Smerling. And again, to remind you, all of the video that you will see has been unedited. Not only has been unedited, but the defense has already stipulated, meaning they've already agreed that everything you're going to see other than when we show you the movie, All Good Things. Obviously, that's a fictional movie. But all of this is unedited. So any ideas or statements about what happened in the Jinx or what was shown in the Jinx, what's important, what the evidence will show, is that what you're seeing is you're seeing the original unedited video. What somebody did with it later, which is not going to be for your consideration with respect to what was said, doesn't matter. What's important is what was actually said. So in 2010, this is what Mr. Durst said.
Well, to begin with, you didn't write the cadaver note, is that what you're
I
saying?
didn't write the cadaver note.
In 2012, he was asked again the same thing.
So, I guess the question is, did you write the cadaver note?
No, I didn't write the cadaver note.
In 2015, after he was arrested and he was interviewed in New Orleans, he was directly asked, again, did you write the cadaver note?
You agree, you did not just find Susan's body and somebody else killed her.
I did not find Susan's body.
So, Mr. Durst makes clear he did not write the cadaver note and he did not find Susan's body. And that was his position up until the evidence is going to show didn't write this, despite the similarities. That was his position until a couple of weeks before trial started. He admitted in a stipulation, yes, I wrote the cadaver note. Now, the evidence is going to show that this was an extremely significant admission. One, the evidence will show he really didn't have any choice but to admit with the evidence that he had written it. But that's not the only thing about the cadaver note that becomes important. Because in 2012, Mr. Durst made clear, and this is going to be one of the few things that the people's evidence is going to show, that Mr. Durst said that absolutely the evidence support. So what Mr. Durst is about to say, the evidence is going to show that this is an absolutely true and correct statement. And this is what he said.
You're writing a note to the police that only the killer could have written.
Now, at the time Mr. Durst made this statement, he knew that he had written the note. But he also knew that at that point in time, no one had proven he had written the note. So, the evidence will show he makes the admission that yes, that is a note that only the killer could have written. Now, is that the only time that he said that? That was back in 2012. In 2015, the issue comes up again during his interview. What does he say?
Whoever wrote the note was a part of killing her.
Yes.
You agree, right?
Yes.
No question, right?
Whoever wrote that note had to be involved in Susan's death.
There's no equivocation. There's no qualification. There's a direct statement that whoever it was who wrote that note is Susan's killer. As with a lot of the evidence in this case, it's going to come right from the defendant's own mouth. Now, who is Robert Durst? And this is important because you have to, when you're analyzing the evidence, say to yourself, well, wait a minute. Why would Mr. Durst end up saying the things that he says? Why does he say so many things that are inculpatory, that get him in trouble? And you have to go back and you have to know, who is he? Well, Robert Durst is the millionaire heir of Seymour Durst, who ran the Durst organization. This is one of the largest privately owned real estate conglomerates in Manhattan. And Robert Durst, and this is why the evidence will show that he makes the statements that he does, that he lies the way that he does, is he is someone who believes simply the rules do not apply to him. They just don't. Whether it's, and again, I don't have the clip this time, whether it's Mr. Durst explaining why he would get food stamps when he's an extremely wealthy person. The answer was, well, if they can get them, why can't I? You just say you don't have any money. Mr. Durst has lived his life pretty much doing whatever he wants, whenever he wants to do it, to whoever he wants to do it to. Certain personality characteristics of Mr. Durst become very important in this case. One of them is the fact that Mr. Durst is admittedly very tight with his money. Why is that going to be important? Well, it's going to be important because later on he's going to be giving Susan Berman an incredible amount of money. And the evidence is going to show that that is stay quiet money. And eventually, whether it was the money he was paying, or more than likely, the threat that she just was going to expose him, that's a loose end he needed to tie up, and that's what he did. And just backing up a second, the evidence is going to show that Mr. Durst did not want to kill Susan Berman. He didn't kill her out of hatred. He didn't kill her out of revenge. He didn't kill her because he disliked her. He killed her out of survival. He believed, and this comes from his mouth, he believed that in the end, it was her or me. I had no choice. And what the evidence is going to show is that you can fault Mr. Durst for the murderous nature of his conduct with Susan Berman. But what you can't fault him for is, from his perspective, the necessity of having done it. The problem the evidence is going to show with the murder of Susan Berman is that Mr. Durst committed that murder about 20 years too late, because Susan Berman had already told her story to numerous people. So, what's the history with Bob Durst and Susan Berman? Well, they met at UCLA. And Susan Berman would probably become, if not his closest and most trusted friend, certainly at almost the very top of that list. So to understand that friendship and to understand that dynamic, you have to understand first, who was Susan Berman? Who was this woman? Well, they met in the 1960s while Susan, They met in the 1960s while Susan Berman was at UCLA. Bob Durst at the time, he had graduated from Lehigh, although he would later claim that he was getting his master's degree at UCLA and that he had actually received a degree. He was basically in California, by his own admission, avoiding the draft, smoking pot, and having a good time. So they met and they bonded. And they bonded because they had very similar backgrounds. Both, tragically, Susan lost both of her parents by the time she was 12. Her father, Davy the Jew Berman, which was his nickname, was a mobster. He was a person who had taken over the Flamingo in Las Vegas after Bugsy Siegel had been killed. And Susan grew up kind of a little princess. Her mom was a showgirl, and by the time they were 12, her dad was dead, and her mom had killed herself. Now, Bob Durst also had tragedy. His mother died when he was very young, and he was basically raised by governesses. So they bonded. So who was Susan Berman? Well, because of Susan's mafia upbringing, she maintained a strict code of honor with respect to intense loyalty to her friends. Susan was loyal. This is something that Linda Obst will be testifying to on this case.
Loyalty was everything to Susan. She learned it from her father. It was the mafioso way. If you had a friend who took care of you, you took care of them for life.
Now, although Susan was very loyal to her friends, she could also be highly manipulative. Murder victims, like everybody else, are people. There is a tendency for all of us, and we all know this kind of in our personal history, when somebody dies, we tend to only focus and remember the good parts of them. That's just how people are. But the world is more complex. Most people have good parts to them and bad parts of them. And I'm not going to stand up here and tell you that Susan Berman was not a manipulative person. She absolutely was. That's what the evidence is going to demonstrate. And it's that manipulation that got her killed. She's very confident. The evidence is going to show that basically she was handling her situation with Bob Durst for almost 20 years. And although the evidence would suggest that Susan never would have intentionally done anything to hurt Bob Durst, she was playing with fire. Bob Durst was giving her lots of money. Was he giving her that money because they were close friends? Well, the evidence is going to show that's not how he treated his other friends. Or was he giving her the money because in the end, there are some people in your life that you need to make sure, no matter what, that they are satisfied with your relationship. And that's what the evidence is going to demonstrate. Now, Susan was killed December 22nd, that evening, or the morning of December 23rd, 2000. You remember, she goes out with Richard Markey. She sees the movie Best of Show. She drops him back off. She comes home. And the next morning, her dogs are running around outside loose on a busy street. But this story goes back to Kathy Durst. This is where it started. So who was Kathy Durst? Well, in the fall of 1971, when Robert Durst was 29 years old, he met 19-year-old...
On the 12 o'clock hour, is this a logical time for you to break here?
Sure.
So I'll let you... I'll then excuse... I'll interrupt you then. So pardon me for the abruptness, but since you're facing the other way, that's the only way I could do it. We're getting used to the logistics of a large courtroom. So, ladies and gentlemen, 1:30, and we'll go right back into this opening statement for the last portion of it, and we'll see you then. Do not talk about the case or any of the people in it with any other juror. Do not make up your mind about the verdict or any issue until you discuss the case with the other jurors during deliberation. We'll see you at, yes, question?
Did we answer on the first floor then? From now on?
You,
Yes, and I spoke with the bailiffs.
yeah.
The system is showing up now.
Okay, they're going to show you the best way to go. I mean, you can come in any way you want, but probably the best way to come in is where people won't bother you. The bailiff's going to show you the way. Okay, first floor is probably the best route. So we'll see you at 1:30 p.m. They're waiting outside?